Dear Heavenly Father, Lord, creator of all things, we come to you this afternoon, Lord, and just thankful for the many blessings you've given each and every one of us here, Lord. Thank you for the blessings you've given our nation. We just pray that you watch over us, guide and direct us. Help us to make good, solid decisions, Lord. We just thank you for your kind and loving grace that you give us each day, Lord. Fill our hearts with joy and love. In Jesus' name, amen.
Thank you.
Meredith Rayleigh. Here. Bill England.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Buzzard.
Here.
Julia Coach. Here. Bradley Cobb. Joe Crittenden.
Here.
Jody Fishinghawk. Janelle Fulbright. Don Garvin. Chuck Hoskin Jr.
Here.
China Glory Jordan.
She
China. Yeah, here. Curtis Snell.
Here.
Chris Soap.
Here.
David Thornton. Kara Callan Watts.
Honey,
We do have a quorum.
we have a quorum. And next item is approval of minutes, and if there's no objection, I would request a motion to approve the photos.
Second.
Any discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries.
Madam Speaker.
Yeah, whichever was first.
I'd like to make a motion to amend the agenda. We have some people here to be nominated, and through the working people, they need to get back to work, so make a motion we do that first. Items 2 through 8, 2, 3, 4, 5, 6, 7, 8.
Items 2 through 8, you want those to go before reports? Is that what you're asking? Everyone?
Second.
Moved and seconded, amend the agenda to move items 2 through 8 before reports. All in favor, signify by saying aye. Aye. All opposed, same sign. Yeah.
Madam Speaker, I would also like to amend the agenda to substitute the name on item number 6 of Mary Horse Chief in place of Linda Van. Linda Van has declined to the nomination, so we would like to substitute Ms. Horse Chief instead.
And we do have a resolution to do that. Moved and seconded, any discussion? Mr. Hoskins?
I withdraw.
Any discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Okay, so under new business, item 2.
I was going to move to amend the agenda.
Oh, I'm sorry. Go ahead.
With respect to new business item 1, discussion possible action on appeal. Really, it could go right under that because it's related. It's a resolution authorizing the Cherokee Nation to join the appeal of Councilors Fishinghawk and Jordan, and it addresses one of the issues in the underlying case. So we'd like to.
You want to move that after the item 1 would be item after item 8.
That's true.
Everyone clear? We're moving items 1 through 8 before reports, starting with item 2 first.
Second.
All in favor, signify by saying aye. Aye. All opposed, same sign. Okay. Now, new business. Item 2 is a resolution confirming the renomination of Johnny Earp as a board member of Economic Development Trust Authority. Ms. Knight. Oh, I'm sorry, Melanie.
Thank you, Madam Speaker. This is a renomination to the Economic Development Trust Authority, and Mr. Earp has served on that for quite some time. He's a banker from Grove, and he is here today to answer any questions you might have.
Correction, he's from J, not Jerome.
Oh. Mr. Earp, you want to come forward? Good afternoon, and thanks for coming today. Does anyone have any questions of Mr. Earp?
Thank you for that correction, Arne.
I'd entertain a motion.
I make a motion to approve.
Do you have a second? Moved in second now. Discussion? Well, I guess unless you want to just say something.
No, thank you.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Mr. Earp is approved. Item 3 is confirms renomination of Judge Bart Fite as a district judge of the district court.
Thank you, Madam Speaker. Judge Fite is here today. This is a renomination to the District Court of the Cherokee Nation. and his term is getting ready to expire, so the principal chief would like to renominate Judge White.
Any questions for Judge? Mr.
I'll be more than
Mossman?
happy to come forward. I will be, like Mr. Earp, I won't say anything unless,
You feel like an offended, or?
somewhat, but friendly faces as well, so no, I'm not going to say that.
Mr. Austin, did you have a question?
I wanted to yield to Counselor Jordan because I think it's difficult for her to single.
Tanya, can you hear?
Yes, at this time, I make a motion to table, Mrs. White's nomination.
Second.
Have a motion table in a second. All in favor, signify by saying aye. Aye. All opposed, same sign.
Aye.
Aye. Roll call. Yes is to table.
Joe Crittenden,
Yes.
Jody Fishing, Meredith Fraley,
No.
Janelle Fulbright, Don Garvin,
No.
Chuck Hoskin Jr.,
Yes.
Tina Gore Jordan,
Yes,
Chris Soap,
No.
Curtis Snell,
Yes.
David Thornton,
No.
Kara Cowan Watts,
Yes.
Buell England,
Yes.
Bill John Baker,
Yes.
Jack Baker,
No.
Harley Buzzard,
Yes.
Julia Coates,
Yes.
Bradley Todd.
No.
You mind doing a recount? She missed one somewhere. You want to do a roll call again? Tanya and Jody are not here.
Jody and Janelle not here.
Fine.
I should have, Tina voted. I should only have. That's right, I got 15. Okay, we're good.
Nine
Nine
yes,
yes,
and 6 no.
Okay.
So the motion to table carries. That's right, but thank you for being here.
Thank you.
Madam Speaker, just a clarification, that's just for 1 month, so next rules meeting, he would be back up.
Is that the motion? Tina, was that the motion to table for 1 month?
yes, at this time.
Okay, at this time, all right. 30 days, Judge Fight,
When will the meeting be next month?
the last Thursday of the month.
Last Thursday. Okay, thank you very much.
Yes, thank you. Item 4 is a resolution affirming a nomination of Bill Ando as an advisory committee member of the National Treasures Program. Melanie?
Thank you, Madam Speaker. Bill Ando is here today. He's a staff member for the arts, both performing in other arts of the Cherokee Nation and the Education Services Group. He's been a member of the arts community for some time, both as an employee, a volunteer, and an advisor otherwise. And he's here today, if you have any questions of Bill, to the newly formed National Treasurers Advisory Committee.
Mr. Baker?
I move that he be approved. Second.
Moved in second. And Mr. Ando, did you want to say anything?
No, it would just be my honor to serve.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries. Congratulations. Item 5 is confirms the nomination of Alan Heron as also to the Cherokee National Treasures Program.
Thank you, Madam Speaker.
Move to approve. Second.
Moved in second. Any discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Melanie, you want to stay up there?
I will. Thank you.
Next is the nomination of Mary Horsechief instead of Linda Van.
Move for approval. Second.
Moved in second. Any discussion? All in, yeah.
Is Mary here?
Is Mary here?
She is not. Because of the lateness of the nomination, we didn't know Linda would decline. So we just asked Mary this morning. She's in J today, but she's available by phone if you
I
want.
heard this yesterday, the day before that she was.
Excuse me? We just called her this morning about this nomination. So, yeah.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carried. Item 7 is nomination of Jane Osti as also for the Cherokee Nation.
Second.
Any discussion? Jane, did you want to come forward? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries. And item 8 is nomination of Lori Smiley, also to the National Treasures.
Move to approve.
Second.
Moved in second. Is Lori here? Yes. Lori, would you want to come forward and say anything? Okay, all in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries.
Madam Speaker, if I could take the liberty of just thanking the nominees for their support and service on this, because it's a volunteer committee and of great importance to the nation. So,
Thank you, Melanie. Okay, moving back up to item 1 is discussion and possible action on appeal of Smith versus Election Commission. Mr. Henry?
Yes, well, obviously, the purpose of this agenda item is to give direction, or for the council to choose a direction on the appeal. Last month, if you recall, at Rules Committee, you gave the direction to me to prepare the appeal as to the redistricting issue. We are prepared to do that. Our due date is July 1. In talking with several counselors, I want a definitive direction from the council as to whether the term limit issue should be appealed. It is obviously an issue that some of you will have differing opinions on. So therefore, I think it's very important that the committee as a whole give me direction as to how to proceed. I will give you my opinion on it, and obviously it's my opinion. You can take with it as you will. The purpose of this lawsuit, as Chief Smith has stated, was to get a definitive answer as to these 3 issues prior, a long time prior to the election. In my opinion, a definitive answer needs to come from the Supreme Court on those issues. Undoubtedly, 6 months prior to the election, there will be a number of lawsuits filed by any number of people. However, if there is a definitive answer from the Supreme Court, or there is an answer from the Supreme Court as to term limits, redistricting, that would, in my opinion, go a long ways to squelching those lawsuits. So therefore, it would be my legal advice is to appeal those issues to the Supreme Court. So therefore, we all know what the men in the 5 black robes will have ruled. So therefore, that's the main crux, is give your council guidance on how to proceed.
Mr. Baker and then Mr. Baker.
I'll defer to the older Mr. Baker.
The older Mr. Baker.
I make a motion that we appeal the redistricting portion of the lawsuit.
I will second with the friendly that we also do the term limits, so that we've got an answer.
Hold on just a second, Jack. I think he's getting Jody on the phone.
I was going to do them separately, so that there wouldn't be any question.
Oh, okay. Then I'll just second it without the friendly. Okay.
Hello?
Hey, Drew.
Yes.
All right, I got you in here. Tina, are you there too? Tina?
Hello?
I see everybody. I see that. I think we lost Tina. Tina?
I don't feel like
I'm sorry I missed your telephone call. Please leave your name and number.
Diana?
Yeah, keep me on.
Yeah, hold on one moment. I'm getting,
Okay, thank
Jody on the line too.
Okay, thank you.
Be careful.
Hello?
Jody? Diana, is you still with us?
Yes.
All right.
All right. Jack, you want to restate your motion?
Yes, my motion is that we appeal the redistricting portion of the court order.
Seconded by the other Mr. Baker. Any discussion? Yes, Ms. Cowanlock?
Just, so this is just to clarify is that is to, we send it to the Supreme Court so that there is no question prior to the election, but we have no ability to ask for that to be expedited or anything else, right? We're still at the mercy of court being timely or not. Is that correct?
Except be our fine attorney.
Yes, we will do everything in our power, obviously, to expedite this matter. All parties know how important this is to the running of the Cherokee Nation government and how important it is. And we will ask the Supreme Court to put this on the fastest timeline possible. There's no discovery left to be done. We can hit, a great amount of the briefing has been done, so I think we can get this heard, fairly quickly.
Thank you, Madam Speaker.
Mr. Hoskin?
Didn't we already do this particular portion of the appeal? I thought we directed Todd last month to appeal. Just to be clear.
You did. Last month you did direct me to do this, but I think this would be very clear. This is an agenda item and no one can make any, I'll refrain from any further comment on
I
that.
think that's what
In the abundance of caution, I think that would be appropriate.
I can call the question.
the question has been called. All in favor of the redistricting appeal, signify by saying aye. Aye. All opposed, same sign.
Aye.
One aye. Mr. Soap. Okay, Mr. Baker?
Yes, I make a motion that we appeal the portion relating to term limits of the council and the chief. While I have no problem with the district court's decision, I think we should have a definitive answer from the Supreme Court.
Then moved in second. Any discussion? Any discussion? All in favor, signify by saying aye. Aye. Opposed, same sign. You got your marching orders, Mr. Embry.
One last item on this topic. Before you, I drafted a resolution at the request of Councilor Jordan to join or support their appeal as to only their ability to carry on a lawsuit in their own capacity, in their individual counselor capacity with their individual attorney. Judge Fite had ruled in his district court decision that they were not permitted to bring their own position, so to speak, and we in this resolution would say that we support individual counselors in their ability to get access to the court and access to their own attorneys. The decennial case in this would be Phillips versus Eagle, which I quoted in the resolution. And therefore, if Ms. Jordan would want to add something else, I believe it is an important part of the tribal council, the ability to bring your own actions. We have 17 good minds here 16 of them could be wrong and one could be right. And I believe that one should have the ability to put their position forward. But again, that's my opinion. It's just the will of the council after that.
Yeah, and it kind of wants to get in here anytime. We put attorney fees at the disposal of each council person. So the intent was that one council person that didn't agree with the other 17 would have a fund. They couldn't use the council attorney, but they could hire an attorney to bring what they believe to be right to the forefront. And this is a case where two councilors didn't totally disagree with the council, but they had different points that were not going to be necessarily brought forward by the council attorney for everybody. And for them to not be able to get an attorney and bring that forth and get it before the courts just runs completely against what the council resolutions to put the money in to start with. And even the speaker sent a call out to all of us saying now's the time to hire your own attorney if your beliefs are different than the body. And they did so. They went out and they hired an attorney. That attorney had different arguments on different things than Mr. Hembry, and yet they were relegated to just being represented, by the body. And so I think, for future and stuff, he talks about the Eagle decision, but the Nicolay decision. 14 counselors said phooey, and the one dissenting one ended up going to court and we gave him the money to do it because we think that everybody represents a certain number of people and they ought to be able to bring that forth, and that ended up getting another seat for Tulsa. And wrong with no. But that's the whole part of why we have a fund for council people to hire attorneys, is for them to go forth and try and represent their constituents to the best of their abilities. And I think it ought to be appealed, because you don't know when you're going to want to bring a lawsuit that is contrary to the other 12, 15, or whatever. Thank you.
Yes. Mr. Hodgson?
Thank you, Mr. Speaker. And just to that, I would add that this, of course, we're just restating what is already the law, and that for some reason escaped the fight. But beyond that, this is exactly the same authority that members of the United States Congress have. And in the 80s, there was a budget law passed called Graham-Rudman. And some members of Congress thought that infringed on the Congress's constitutional authority to write a budget. And the one congressman that brought a lawsuit was Mike Sinai. It wasn't the United States Congress that brought the lawsuit. The Supreme Court didn't tell Mike Sinai, come back when you get 435 other folks to come in this room with you. They recognized his authority as a legislator to do that. Judge Fight should have done the same, and I think any court that reviews it would look at Phillips versus Eagle. But I think this is our opportunity to reaffirm what Councilman Bill John Baker said and what this decision said. So I'd like to be added as a co-sponsor. I think Councilor Jordan would direct that to her.
Very much I would like to have and invite anyone on in co-sponsorship at the appropriate Chairman Emeritus.
Appropriate time, Meredith.
You were yielding to her, weren't you?
I was asking if she would add me, and I think she indicated she would.
Can you hear all right, kinda?
Yes.
Okay.
So that's all. I'll yield back to you.
Ms. Calmons, did you have your hand up?
Yes, thank you, Madam Speaker. So, just to clarify, the only barrier is what happened in that court case. 'Cause I remember, and maybe we read a lot, so I thought it was an issue of timing, which precluded them from entering in, and not an issue that they didn't meet deadlines, but not an issue of them having the actual right as separate individual council members to enter in.
Well, if I remember correctly, that was part of it. I think one part of it, Judge Fight ruled that, well, you're just getting in too late in the game. The other part is you're already represented by the attorney for the tribal council, and we've asked for reconsideration of Judge Fight's decision, and we're also planning to appeal. However, I think it would be, I think in my opinion, the council needs to stand firm or reaffirm their ability to bring individual lawsuits and have differing positions, other than being just I won't say reduced, but being set aside to amicus curiae briefs. I think it's very, amicus curiae briefs or print of the court briefs are very helpful, but it doesn't allow you to advocate your position as a real party in interest. And I think it's important that council people preserve that right, because today it's Ms. Fishing Hawk and Ms. Jordan. Tomorrow it may be you, and I think that's and this joining in this appeal is only on that sole issue that they have the right. It's not on anything else. I wanted to clarify that.
Acting in their official capacity as individuals. That's what I'm
Acting in their official capacity as a counselor to bring forth issues before the court.
So just to, thank you, Madam Speaker. So just to, I would really like to be a sponsor, except that part of the title precludes me from being that, because I don't want to join in their particular issue. But otherwise, I'm very supportive of it, but I can't sponsor it for that reason, or co-sponsor it. But we have to absolutely have the right and ability. We are each individually elected. We don't have a boss except for the people who elected us. So I think it's important that we have the individual rights to do our job. So I appreciate that they brought that forward. Thank you, Madam Speaker.
Dr. Cobb?
I want to come at this from a little bit different angle, Councilor Watts, and I'd like to hear one of the rationalization problems I'm having. I hadn't thought about what Councilor Hoskins said, and that was a good point. And in that respect, I mean, that situation, I completely understand that, but one of the problems that I'm having here is the fact that we are elected officials, and I view part of our job as to come to a consensus, no matter how long it takes. I mean, there have been issues that we've batted around since I've been on the council, and several of them, and that's just part of it. That's our job, is to come to some kind of a consensus. So the other problem, the stumbling block I'm having is that we keep using the words individual and individually have the right. I could be wrong, but I gave up some portion of that. I'm an elected official. I'm not here representing myself. I'm representing a district of constituents. So I'm not necessarily yes or no on this. I completely understand and that's what, like I said, that completely turns some things on me, but we keep going back down this path of individually have the right. In my opinion, we gave up a little bit of that as elected officials representing constituents. My personal opinion, and that maybe. So I'd like to hear from Todd on that, if you don't mind.
Yes, and to answer your question, the consensus of the council, and you have a council attorney, you have had for some time, and the consensus of the majority of the council, the consensus of the council will be represented by that attorney. Okay, but we have each individual of you, I believe, has what? 15,000? 5,000? 16,000 apiece for individual attorneys. But the most important aspect to me is the point raised by Mr. Hoskins and the point raised by Mr. Baker. And that's Cherokee Nation case on point. The vast majority of the council approved a reapportionment plan with 9 districts, in which Cherokee County had 3 districts, and that was the vast majority of the council. That was the consensus of the council. Councilperson Lay said, that's not right. That's not what, that's the wrong figures were used, the wrong mathematics were used, and I want to bring a suit. 16 people could have the same opinion. One could be, 16 people could be wrong and one could be right. And what I want is not to have.
If I may.
Go ahead.
Define wrong or right. Because
I don't wear a black robe.
who decides who's wrong? And that's our job.
Well, here's the, let's go with the Nick Lay decision. Okay, I think it was 13 counselors approved that reapportionment. Okay, 13 counselors were wrong. Nick Lay and one other. Nick Lay brought the decision, and the court, the separate branch of government, agreed with Nick Lay, which caused a reapportionment of the districts just weeks before the election, in which Cherokee County lost a seat, and the Tulsa district gained a seat. And just like Mr. Hoskins' example, the vast majority of the House of Representatives were wrong in delegating their budgetary authority to the executive branch, basically. Mike Slaughter brought a suit. He was in the minority. He was not part of the consensus. But the Supreme Court ruled that he was right. So that's what we're wanting to preserve, is the right for an individual council person, not necessarily, Ms. Jordan and Ms. Fishing Hawk, but counselors in the future, to not have a decision where laying out there that someday in the future, Mr. Hoskins, sees that a future council that he's part of a future council, and that future council brings or passes a bad lawsuit or a bad law, he should have the right to bring that lawsuit. And I think it would be detrimental and it would impair the powers of individual council members if somebody would be able to point to this decision in the future and say, no, you didn't have that right. The majority or the consensus of the council was represented by a person. So that's where I come from.
Todd, may I carry on with what you were asking?
If I can do one more thing after that, please. Thank you.
Is there a particular reason why this wasn't written more generally, as Ms. Watts was stating, rather than more specifically for a couple of councils?
As you well know, I draft legislation as I'm requested, and this was the request of Ms. Jordan, and I drafted it in that way. But it is a right that would inure to all.
Right.
Because I think Councilor Hoskins is probably going to address this, and I want to just throw this out there. Part of the problem I'm having here is, where, like anything else we debate and pass resolutions on, is where does this stop? I mean, if you don't like a decision, do you just run to the court and say, I don't like this decision, I'm going to file a lawsuit? I mean, where does it stop? I mean, our job is to sit down and hammer stuff up, and if you don't like the way it went, where does it stop? That you just run to the court and say, I don't like this, I'm filing a lawsuit. That's my concern with all this, and I quite honestly haven't decided how I'm going to vote on this. So thank you very much for your time.
Mr. Baker and then Mr. Hoskins and then Mr. Baker.
Yes. I have a question first for Mr. Henry. They are appealing the decision, is that correct?
Yes, they have filed their appeal.
Okay, thank you. I would also offer a friendly amendment in the title, rather than to join in, that we substitute support, and then at the bottom of the page, now therefore be it resolved that the joins be replaced with supports.
With what, Jack?
Supports. And I would offer that as a friendly amendment.
Did everybody understand that? In the title, rather than say to join in, but to support the appeal?
Yes.
And then in the final resolved paragraph, is that the one you want?
Yes.
Suggested? That it support, rather than joins in, that supports?
Yes.
Okay, do I have a second?
Well, he offered it as a friendly, and see if Tina would accept it.
Okay.
Tina, can you hear us? Tina?
Yes, barely hear you.
Did you hear Mr. Baker's proposed friendly amendment?
Tell them which paper.
Todd, can you repeat it? You're close enough to I can hear better from you.
Yes. Mr. Jack Baker offered for a friendly amendment in the title to change join in to support, and also in the therefore clause to change joins to support. I will tell you, I don't believe that it would impair my ability to write briefs in support of that. I am duty bound to respond to the appeal, and it may be cleaner to have a support than actually join in, because we're going to have our own we're going to have our own council appeal also. So I don't see this as hindering the intent of the resolution.
Yes, I don't know which one of us made the motion in second, but I would ask that amendment be done if that is at all possible.
Well, all you have to do is accept it as a friendly, and the second accept it.
If I accept it as a friendly, and then whenever Meredith can let me, put me in line to comment, I'd like to comment.
Okay.
Okay, I got you down, Tina. Mr. Hoskins?
Well, thank you, Madam Speaker. And just to the issue Councilman Cobb raised.
Has the person who seconded it accepted the amendment?
Oh, yes, I did.
Sorry.
All in favor, signify by saying aye. Aye. All opposed, same sign. That's to amend the title and the therefore. That what we're
Okay.
all right. Now, Mr. Hoskins.
Thank you, Madam Speaker. And just to the point about where does it stop and the concern about rushing to the courts, I guess one thing is true in every lawsuit: you have to have standing. And just because we have a legal authority to sue doesn't necessarily mean we'll have standing in every case. And that's why this language is written the way it is by the courts. The issue is whether the authority and power of the Cherokee Nation Council was impaired. And so back to my example with the Graham-Rudman Act, Mike Sinar thought that the powers of the Congress of the United States were impaired because the Congress did something to themselves that violated the Constitution. We could do that, and every one of us but one could do that, and the one ought to be able to go out and run to the court and say, "Court, I think this is wrong," and the Supreme Court could say, "You're right or you're wrong." If we lack that individual capacity, then it really is we strip ourselves of a really meaningful check, because it could be, Councilman Cobb, that there's no one in Cherokee Nation that could have the standing to bring that lawsuit. It's possible. And I think in the case of the Graham-Rudman case, I don't think a citizen of the United States, in fact, I think there's many cases on that, Todd, where a citizen has tried to sue in similar circumstances, and the courts have said you don't have standing. Mike Sinar had standing because he was an official capacity as a member of Congress. And if the Congress of the United States had somehow prohibited that, and I'll yield in a moment, had prohibited that, then he wouldn't have been able to bring that lawsuit, and no one probably would have been able to bring that lawsuit. That's the fear I have if we don't reaffirm this, or if the court agrees with Judge Fite. And I'd yield to Councilman Cobb because I think he has a question.
That's quite on that. So the path we're going down, I just want to make sure is, ultimately we are citizens of the Cherokee Nation, and we have the right to ask the question, bring it to the court. Because ultimately where I'm going with this is, the question may arise, yeah, but every citizen of the Cherokee Nation doesn't have a $15,000 fund.
Councilman would yield back ours.
Yeah, please, I just want to ask that question.
It's our official capacity. Our constituents probably lack the capacity to go to court and have standing. They probably do by virtue of their citizenship. It's by virtue of the office that we're granted, for whatever time we're granted it, that we have that capacity. And when we leave, the next person does. So that's what we have to protect here, that individual office holders charged with the duty to protect this council as an institution and uphold the Constitution can go to court, regardless of whether the majority may say otherwise. I yield back to you.
Mr. Baker,
Yeah, and Brad, in your earlier comments, Tina and Jody didn't rush to court because they disagreed with their decision on council. They rushed to court, or they didn't rush, but they went to court because the chief went to court over something he disagreed that we did. And they just went because their reasoning for voting for it and their reasoning for appealing it did not follow right down the middle of what you and me and some others thought. So they appealed, and they had the right to appeal, but they were thrown out. And I'm just saying we need to preserve that right. I'll go to the top.
Mr. Henry, and then Ms. Jordan's waiting also.
Let me make one more real-life example of the Cherokee Nation. At one time, the Tribal Council, several years ago, had passed a law that said that the chief and deputy chief were ex officio members of every committee of the Tribal Council, and could be a part of the committee process. The majority, obviously that was passed by a majority of the Tribal Council. One councilor had brought a lawsuit saying that that was an infringement of the separation of powers doctrine. The suit ruled that rule was unconstitutional. What if the next council, at a vote of 15-2, that a council passes a similar law to that? Well, those two councilors, although they are not part of consensus, that is a part that impairs the ability, that impairs the right of the tribal councilor. And they would be those two that voted against it would be the only two that have standing. Dare I evoke the name of Robin Mays? He would not have standing to bring that action. Only a councilor would have standing to bring that case to the court. So that's the point I want to make.
Ms. Laura Jordan, can you hear?
Yes.
Okay, you have the floor.
Okay, my comments will be somewhat short because I don't want to take a lot of time, and all the comments that have been made are very consistent with some of my concerns. I feel that this decision is totally inconsistent with a series of cases that have already been decided by our now Supreme Court of Cherokee Nation. If we let this decision stand, taking away a fundamental right that has been given to each of the tribal council members in their official capacity, that right that was previously given to you by this series of cases. And I simply do not want to let this stand. I always agree with all of you all. You don't always agree with me, but I think we should be united in not allowing a fundamental right and gift that for us to do an adequate job for our people, not allowing that decision to stand. And I would ask me, and moving this forward to the Supreme Court, where I believe it will be corrected by them simply looking at what they've done in the past. Thank you.
Thank you, Mr. Jordan. Mr. Garvin?
I just have an answer, question for Todd.
Sorry, I was just contacting with our attorney general.
It looks like we have two deals going here, and one is concerned with the council and one with two individuals. Will the two individuals slow down the council, what they're doing, will it speed up? What effect is this going to have on our case?
It would have no effect. We will file our appeal on the two issues that you gave me direction to by probably tomorrow. They have already filed their appeal. This resolution is in support of that, and I think actually the language support is better than join, because there won't be any confusion on the court of we're an active part in that. But it will allow me to, in my briefing, support the positions that they take. So to answer your question, it will not slow down the council's appeals of the issues.
Okay, you're going to be an attorney, and there's going to be some other attorneys, so how will you coordinate all that?
By in person or telephone. I mean, and that brings up a good point. This, at any time, this does not prevent any individual counselor, even on my issue, even on the council's issue, of filing amicus curiae briefs. You all still have that right, okay? But the council's given me a direction, and And I'm still just the attorney for the council, and you've given me directions to support their position and also to appeal the other two issues. So it doesn't affect what the council as a whole does.
So if I decide to follow what you mentioned there, drainage, and Bill, everybody go up there with 15 more attorneys and 15 more, still be okay.
15 more briefs. It might take them longer to read those briefs, but it's not going to slow up the appeal, in my opinion.
Call for the question.
Thank you, Madam Chair.
Question's been called. All in favor of this resolution supporting Fishing Hawk and Jordan, signify by saying aye. Aye. All opposed, same sign.
Aye.
One aye. Okay. Moving back to reports now. Sharon Wright, I don't think there's anyone here from the Marshal Service. They're at a Trail of Tears function. So it's Ms. Hammond.
Thank you, Madam Speaker. Good afternoon.
Good afternoon.
The only two issues that I wanted to bring to your attention, in addition to the things that we informed you about in our report, was the Continuing Legal Institute. We've had the first one going on for the last 6 months or so with Imogene Alexander and that group. A lot of the young people are people that have been on the Youth Leadership Council. They're, I think, 15 to 18 years of age. This week, they are preparing a moot court trial, and the trial itself will be tomorrow evening at 6 o'clock at the courthouse. Part of it will be in Cherokee, part of it will be in English, and it is the trial of Major Ridge, who, as you know, received no trial. He received an execution, but no trial. So anyway, they are very, very interested in it. It's a great group of young people. It's a little intimidating to try to teach them anything because they are very, very well versed in our history. We've been assisting with that, and I encourage you, if you can, to attend that tomorrow evening. The other thing I wanted to inform you, I think that I formally notified...
Diane, can I break in just a
Oh, I'm
second?
sorry.
Can we get more information on that, or would we be able to observe that? And that would be
Yeah.
really interesting.
Yeah, at the courthouse tomorrow evening at 6. Anybody can come and watch.
Okay.
And the kids are playing the roles like it's Major Ridge and the attorneys and everything.
Will that be video?
You know, I don't know. Justice Poteet is presiding.
No bias there.
Thank you. Certainly. I think I notified the council. I know that Mr. Hembry and I talked about it. The Freeman case in our tribal court has been set for hearing on the motions for July 17th at 2 p.m. That's in front of Judge Cripps. That's his regular docket day, but he's specially set that in the afternoon after the conclusion of his regular docket. There are motions for summary judgment pending from both sides, from the nation side and from the class side. Mr. Ralph King Jr. represents the Freedman class. The legal issues are before the court, and we will be arguing them at that time, and absent the court asking us to brief something else or for more information, then it will be right for a decision. So, of course, that's open to anyone who would like to attend.
Diane, what was that time again? It's 17?
July 17th at 2 o'clock.
Okay, thank you.
Absent that, I'll be happy to try to answer any questions you may
Any
have.
questions? Yes, Mr. Hoskin?
Yeah, I appreciate the documents you sent me. Madam Speaker, I had asked the Attorney General to comment on a cease and desist letter that was sent by her office to a webmaster that hosts a Cherokee political-oriented website. Now, I've got some concerns about it, and I just wanted to ask her a few questions, if that's all right. I've got the copy here. I don't have all the documents that you sent me. It's just in terms of an example, the June 12th letter. Would you, actually, I guess just pass that around. It's my understanding that the Cherokee Phoenix believes that its copyright was violated, and it has obviously the right to assert that copyright and issue cease and desist letters, but your office became involved in it. Your office sent out the letter to the webmaster to do that. And I guess my concern is, I don't begrudge the Phoenix at all for wanting to enforce its copyrights. In fact, it should. I guess my concern is that is typically a private right asserted by a private party. And here, where the copyright is sort of the underlying or maybe background issue, is this website happens to be not just anti-Chief Smith, but frankly anti the government of the Cherokee Nation from some of the stuff I've read. There's very inflammatory rhetoric on there, but it's political rhetoric. And so, that aside, if this was just a private matter, I don't think anyone could really begrudge the Phoenix from asserting its right, but when your office gets enmeshed in that, then it becomes one of the highest ranking public officials in Cherokee Nation sending the cease and desist letter. So I guess I have concerns about that, and I guess I'm curious as to, did you have an obligation to represent the Phoenix, or was it discretionary?
I do have a legal obligation to represent the Phoenix, I believe, based on the statute, the Attorney General statute. We have the obligation to represent all of the boards and commissions and entities of the nation. Now, sometimes we can't do that because conflicts arise and there's mechanisms that we have to employ, you know, if there's conflicts between departments of the nation or entities of the nation. The specific paragraph is in the Attorney General Act. It's paragraph 12. To furnish legal advice to nation officials and all executive departments, boards, commissions, agencies, instrumentalities, and officers of the nation concerning in any matter arising in connection with the exercise of their official powers and duties, et cetera, et cetera. In this case, the Phoenix could have hired outside counsel to have done that. We would have had to look at the attorney contract, as we do all attorney contracts, not for the substance of the representation, but to make sure there's no waiver of sovereign immunity or any of that thing, any of that sort of matter in there. We believe the Phoenix contacted us and said, we think our copyright's been violated. What can we do about it? One of my attorneys researched the law, contacted the webmaster, and you've got the letter, and brought it to their attention.
So could you have declined for some policy reason to, not the underlying legal merits, but just for policy reasons to decline to represent them?
I could have.
And I guess, and this is, the existence of this letter is fairly new to me, so I haven't had a lot of time to consider it, but it just seems to me that where we're talking about a free and independent press asserting its rights, but to do so on the Attorney General's letterhead strikes me as a little over the top and have a potential chilling effect, number one, on speech. And number two, have undermined the independence of the Cherokee Phoenix. When the government of the Cherokee Nation, through its highest ranking legal officer, is asserting this copyright claim. So I just have some concerns about that. And if the Phoenix doesn't have sufficient funds for legal counsel to assert its rights, then I think we ought to make sure they have it. Because I would rather see the Phoenix use its own attorney, outside counsel, to assert these kind of rights, particularly, but not necessarily, but particularly when the target of the cease and desist letter is just renowned as being, again, not just anti-Chief Smith administration, although I think he bears the brunt of the criticism on this side, but anti-government, anti-Cherokee government, period. And that actually is the kind of speech that, like it or not, we ought to kind of stand up for. Now, they shouldn't violate copyright, but again, when the Cherokee Phoenix is asserting their rights under copyright, I'd just rather it not be under the letterhead of the Attorney General of the Cherokee Nation for policy reasons.
Well, I understand your concerns, and it's political speech is not only entitled to those First Amendment protections, that's the highest level of First Amendment protection. I mean, you know that from law school. We all understand that political speech gets far more protections than commercial speech or any other sort of speech, and I'm a firm defender of that. In this case, it wasn't the content, just for the record, so everyone understands, it wasn't what Mr. Cornsilk's board was saying about anyone, any of us, the chief, anything. It was, what they were doing was they were cutting and pasting articles that the Cherokee Phoenix posted, putting it on the website without saying where it came from, without listing the author who wrote it, so they were stealing that author's content. So that's the copyright violation. Ms. Nemo wrote them a letter, wrote the letter to the webmaster. She provided a courtesy copy to Mr. Cornsilk, who of course put it on his site, and said, this has happened, here's where the original was, here's my authority to bring it to your attention, please remove it. The next time that it happened, she cited another provision that said not only could you remove it, we're asking you to, but you could shut down the site.
And I concede to you that they had a valid copyright claim to press and that they ought to be able to press it. But can you appreciate that for people, particularly people who aren't maybe versed at all in copyright law, might see that when the Attorney General sends a cease and desist letter out to a website with these kind of headlines, and when folks in Cherokee Nation know what this website does, that they might think the government's cracking down on this website. Now that's too oversimplified, because it doesn't go to the underlying issue that there was potentially a copyright violation. But when it goes out under this letterhead, boy, it sure, I think, it changes the dynamics, and I think it gives people the impression that they ought not to take away, but I think they will take away. So I guess I'd encourage, I'm not asking for an answer on the spot, I'd encourage you to consider whether in the future you should decline for policy reasons. And if you do that, I think the council sure ought to make sure that the Phoenix has sufficient funds to press these claims all day long.
I do appreciate your concerns, and I guess the only response that I have to that is that I hope that seal at the top would impress, that you can't steal stuff and use it as your own and claim it as your own. Now, and I fully know what, the site has made of that it's the administration trying to squelch the little guy and trying to shut him up and trying to do all those things. But if you read the letter, if you look at what it says and what its intent is, that doesn't have anything to do with it.
I understand that. I mean, and if the New York Times wanted to sue a web blog, they could do it. And they wouldn't use Eric Holder, the Attorney General of the United States, to do it. Now, there's an underlying reason why they wouldn't, because there's no relationship between the United States government. But we pride ourselves on having a newspaper that holds itself out as a free and independent press, as free as independent as possible. And it just seems to me that when the Attorney General asserts its copyright, that doesn't go far towards supporting this idea that they're free and independent. And I don't want that to happen. So that's my concern.
No, I understand. I think you could also argue that it's our duty to make sure that free and independent press is protected.
Which we could do through funding as opposed to a letter.
Two attorneys.
Thank you, Minister. Thank you, Attorney.
Thank you.
Yeah, and I agree with Charles about, I know your authority for the boards and commissions and stuff, but I truly believe that commission is different. That one is the free and independent press. Just like I really don't think you ought to be representing the election commission, because it's supposed to be free and independent. All the others, the gaming, all the others, I think, are under you. And you'll argue that they're all under you. But I think we really need to be careful, if nothing else, for the appearance of the government over the press and the government, coming in when, in fact, we would gladly give them money for an attorney, as we have for the election commission. And I just think that, at some point you're going to conflict yourself out. And I think that needs to be guarded against.
I try very hard to do that. The Phoenix asked us to help them on this, and we did. The Phoenix has asked us about other questions that we didn't feel like we had the capabilities to answer. They went to outside counsel. I tried to be very cognizant of those issues. Because of this, I didn't, and I was aware, of course, of the nature of the site. I didn't see a problem with it.
And Dr. Cobb?
I do agree with what you said. I just want to throw out that irregardless, the perception becomes that there is a link between the government and the press. but I will submit that giving them money does the same thing. And so my point to this, I don't know what the answer is. And I'll yield to Councilor Hoskin. I don't know what the answer is, but that accomplishes the same problem.
You're right. I mean, the money is a link, but I suppose it's a less direct link. I suppose, you know, people don't have to stare down the barrel of the Attorney General's letterhead if they're funded to get outside counsel. I have a question. I assume the attorney-client privilege attaches to your discussions with the Phoenix as to this issue, and in terms of what led up to the decision to issue this letter to this web host.
Yes, I would.
Because I don't have this question at the moment, but suppose down the road, you know, there's 100 of these letters, and suppose there's actually 1,000 potential copyright violations from all sorts of websites, maybe just news services that have no political bent, but this site's the one that keeps getting them. We may want to ask, why do you keep targeting this website? But we can't know that. That's your client. But you're also a government official who should come to this council and answer to us to some extent as to why you've taken certain action. So I guess that's another reason that, in my view, outside counsel would be better. Because at least that outside counsel wouldn't have the obligation to come to us, and there wouldn't be that issue. But it does raise the concern. I mean, if this continues and it looks to some like it's targeted, then we ought to be able to ask questions about it, but we won't, because we won't be able to get beyond the privilege that attaches to your relationship with Phoenix.
Mr. Pollard could waive that privilege, or he could answer it himself, as you know.
Sure.
Todd?
One thing is that we need to be aware of is that the council grants the authority, what authority the Attorney General has that she has through the statute that is provided. What authority the Election Commission has provided by the statute that this council passed. Same way with the free and independent press. One way that you may want to rectify concerns is to bring an amendment to the Free and Independent Press Act and put in a section very similar to that you have in the Election Commission statute, is that they have the authority to hire an independent counsel free of any political influence. We'll have, I can't recite the language off the top of my head, but we'll have no other contact with the Cherokee Nation government. That's in the Election Commission statute, and you know, that might be a resolution to the appearances of the conflict that we've talked about.
That poses a question.
Ms. County-Watch. Ms. County-Watch.
Thank you, Madam Speaker.
Mr. Hoskin.
I guess I don't want to leave folks that might be watching with the impression that anyone's picking on the Corn Silks by any means. That particular website really doesn't have a lot of competition. So by logistical nature, if there's only one, maybe two. There's a couple of blog sites out there that also challenge the Cherokee Nation and us as elected officials, which I always appreciate as well. But really, they're the only game in town, so to speak. So maybe just so anyone watching doesn't get a different impression, they are obviously going to then be the only ones getting letters. Thank you, Madam Speaker.
Well, they're...
Well, yeah, let the Attorney General respond, and I'll...
Thank you. They're the only ones that got letters because they're the only ones that have done it. I mean, the people that are in the business of printing newspapers and magazines and those sorts of things don't typically do that. And one had hoped that after the first letter educating the site and the poster of the site, that they wouldn't do it anymore. They could print anything they want. They could print, they could comment. You just can't steal someone else's work, pretend it's your own.
And I mean, my concern is down the road. There's some weblog called ilovechiefsmith.com, and it's all going.
I think it's in the works. I hear he's developing.
I'll be a frequent poster. And they steal the Phoenix's work product. And then down the road, people say, well, you know, this pro website was not touched. And I'm not saying you would do that, but you're not directing it, and the Phoenix is directing it. But then if we want to ask you, well, did you have discussions about these others? We can't get to that issue.
Sure you can.
Well, if they waive it. But they don't have to waive it. We don't have to make them waive it. We can't make them waive it. But Mr. Hembry, are you saying that the Phoenix's board could not have hired outside counsel because they don't have the authority to do it?
No, they can't. They could.
But we could make it clear.
We could make it mandatory that they did.
Oh, so your language is mandatory that they did?
Yeah.
All right.
Just like we have an election.
Just like that, okay. All right, thank you. Thank you, Attorney.
Mr. Baker?
And Mr. Henry, I would ask you to research that and write that. I would-
Any other questions, comments from Ms. Hammonds? Ms. Chris?
Yeah, I've got a question about you mentioned copyright law and provisions. Where is that detailed out in our laws? Can you give that information?
I can. It was actually federal laws that we cited.
So we're referencing our federal laws. And so if you follow up on those federal laws, what are your intentions, I guess, or could be your intentions? You've been nice, I would assume, and just kind of been sending little letters, but actually if there's laws being violated and broken, I would assume that your office would follow up on those and pursue them to the extent of the law. And so if we're citing federal law, what are some of the options available to the government as far as getting justice for the Phoenix?
The Phoenix could, down the road, if it chooses, engage in civil litigation, and there may be, and Ms. Nemo may have to educate me, are there criminal penalties?
There are criminal penalties for repeated malicious copyright.
So what are those criminal penalties, and would that come from the federal officers, or would that come from?
If there's a federal crime, it would have to be prosecuted by the U.S. Attorney's Office.
Okay.
And they're fairly minimal. I think they're federal misdemeanors, 6 months to 1 year, up to $20,000, and prosecuted by the federal office.
Appreciate that, thank you.
And anything else?
Thank you.
Oh, Dr.
I just
Cox,
had
a question.
a question. Would that be in federal court or Cherokee Nation? I mean, we're a sovereign nation. How does that work, I guess I'm asking?
The way, with any other thing, I'm not talking about this at all, but if there's a violation of federal law, then it's prosecuted by the U.S. Attorney's Office. Now, our law enforcement often helps them, and they're cross-deputized with the federal officers, and the federal prosecutors rely on them a lot, but that's the federal court. Councilman Hoskin, I do appreciate you giving us the heads up so that we could prepare the material and answer your question. I appreciate that very much. Thanks, sir.
Thank you, Ms. Hammonds.
Thank you.
Election Commission, I don't think there's anyone here. They do have the report in the book. Tax Commission, Sharon. Good afternoon.
I think you do have my report, and I'll try to address any questions that you might have.
Questions or comments for Ms. Webster? Thank you for being here. Thank you. Oh, you're reporting from Vicki, aren't you?
Good afternoon. My name's Angela Thompson. Vicki's out today. If you have any questions, I will try to answer. If I can't, I will follow back up.
Any questions? Yes, Mr. Moser?
I have a question on the DY portion of the stimulus package. I know our roads program are in line to get $11–12 million. I'm concerned, what are we doing at the nation level to make those things happen? I thought they were going to come down, fairly quick like that's what the Obama administration put out. And here we are in July and we haven't got anything. What are we doing?
Right now, we're working with the Department of Interior. They have come up with an addendum that they're wanting us to sign. We're reviewing that, but DOI is being the most difficult in getting those funds distributed. So that's what we've been doing so far.
So, do we know a date or any time that we may get them? Because construction season is this summer.
Right.
Get something going. I'm not going to be sitting here all the stimulus money and it's not going to be doing any good.
I do know that Vicki, we did meet yesterday, and I do know that Vicki is working on that diligently and trying to get the addendum signed and getting all the questions answered, and so that we can get the funding to the nation so we can start expending those.
So as soon as the addendum is ready to go, then it's come back to the nation for signature. And I guess we're prepared to sign off on that as soon as we get it.
Well, it's depending and making sure that there's not any regulations that, that we cannot adhere to or that we don't disagree with or there's no issues on.
Thank you, Madam Chair.
Any other questions, comments? Thanks for being here. Thank you. Anyone from the Gaming Commission? And Mr. Hembry? Modification?
I met with Mr. Morton shortly after our last meeting. Again, we divided up projects between the individual attorneys. I hate to sound like a broken record, but we're closer than we were last month, but we're still probably another couple months out before we can submit it to this committee for final approval.
Any questions, comments, or Mr. Todd? Thank you, Todd. Old business, there's none pending. Moving on down to announcements. The only announcement I have is I was told that Mr. Garvin is celebrating his 50th anniversary. Wedding anniversary. She must be a very patient lady.
She is.
Congratulations, by the way.
Well, thank you very much.
Any other announcements? Entertain a motion to adjourn.
So moved.
Second. All in favor, signify by saying aye.
Aye.
Opposed, same sign. We are adjourned at 2:22.